All the following cases happened in Washington, D.C.
The representative from ExxonMobil is here.
Okay, send her in.
Listen, the election for mayor is coming up in 59 days, and I was thinking we could help out Kendall Viator by broadcasting some election-related communications to really get a name out there.
No, that's not acceptable. I'm pretty sure that's illegal due to the bipartisan campaign.
Actually, I've done some research, and according to Citizens United, which is the Federal Election Commission, it really isn't.
February 21st, 2010, in Washington, D.C., the Supreme Court ruled in favor of Citizens United, stating that Clause 203 of the Bipartisan Campaign Reform Act represents an undue violation of the First Amendment right to speech. This is a landmark case because the decision permits for much broader campaign financing and financial support of political candidates. Theodore B. Olson was a lawyer for petitioner, and Elena Kagan was a lawyer for respondent. The petitioner claim was that the Bipartisan Campaign Reform Act violates the First Amendment by prohibiting unions, corporations, and nonprofit organizations from broadcasting election-related communications within 60 days of general election or 30 days of a primary election. Justice Kennedy believes in the BCRA prohibition of all independent expenditures by corporations and unions violated the First Amendment of free speech, while Citizens United argued that the First Amendment purposefully keeps government from interfering in marketplace ideals, and it is not up to the legislators to decide.
You can't write that about me. That's not even true. You're gonna ruin my reputation. You have to fix this.
Actually, I don't.
I'll have you know, a similar situation occurred on March 9, 1964. In New York Times versus Sullivan, the Supreme Court ruled that the advertisement could not be considered malice. In this case, malice was defined as the desire to inflict injury, harm, or suffering on another, either because of a hostile impulse or out of deep-seated meanness. In this case, malice was not inflicted on Sullivan and was not inflicted on Lauren either. The chief lawyers for the New York Times were Herbert Brownell, Thomas F. Daly, and Herbert Weschler. And the lawyers for Sullivan were Sam Rice Baker, M. Roland Nachman Jr., and Robert E. Steiner III. This civil liberties case gave more power to the First and 14th Amendments so that the state's court's power is limited regarding giving money for damages. The $500,000 that Alabama gave Sullivan was rescinded due to the Supreme Court's decision. This case is important because the standard of malice was set and cases with similar problems would be easily solved in the future. The arguments it contains includes that Justice Black believes that the states shouldn't be able to give out money for damages, while Justice Goldberg thought that there should be no malice and no restrictions on freedoms. He believed that the Founding Fathers made the constitutions to have no limits on speech and press. I, the New York Times, have obtained a copy of the Pentagon Papers and have published them for you, the people.
I, Richard Nixon, under the Espionage Act, will claim that this is an issue of national security and will use my implied powers to stop the presses before they run, using prior restraint.
This case took place on June 30th, 1971. In New York Times versus United States, the chief lawyer for petitioner, the New York Times, were Alexander M. Bickel and William E. Hegarty, and the chief lawyers for the United States were Daniel M. Friedman, Edwin N. Griswold, and Robert C. Mardian. The petitioner's claim was that the government couldn't prevent them from publishing the Pentagon Papers because of national security issues. The Supreme Court's decision was that the government cannot prevent a New York Times from publishing the papers due to the First Amendment's freedom of speech and press. The civil liberties case is significant because it expands freedom of press and restrains government powers. The main argument from the New York Times was that the First Amendment's freedom of press protects the newspaper, and there is no proof that it endangered national security. And the United States said that the First Amendment does not guarantee absolute freedom of press, especially if it causes an issue with national security.
Who would send something so provocative? This should be illegal. I'm calling the police.
Miller v. California took place on June 21, 1973. The chief lawyer for the state of California was Michael R. Capizzi, and the chief lawyer for Miller was Burton Marks. The state of California stated that distributing the material was a misdemeanor according to the state laws. Miller claimed that California's definition of obscenity did not match the one set forth by the Supreme Court, and that his conviction in the California State Court should be overturned. Chief Justice Burger argued that the material was obscene and that Miller was guilty, while Justice Brennan argued that the law was overbroad and unconstitutional and that Miller was not guilty. In this civil liberties case, the Supreme Court gave up and upheld California's verdict. This was a landmark case because it redefined obscenity as to be judged by the average person applying contemporary community standard, and if the work offensively depicts sexual conduct. This created a clear definition of obscenity.
You're a minor under the Communications Decency Act and are not allowed to look at obscene material on the internet.
Let's see about that.
Reno versus ACLU happened on June 26, 1997. The chief lawyer for Janet Reno was Seth P. Waxman, and the chief lawyer for the American Civil Liberties Union was Bruce J. Ennis. The petitioners claimed that two provisions under the Communications Decency Act were unconstitutional under the First Amendment freedom of speech. The decision in this civil liberties case was that the act that prohibited indecent transmission and patently offensive displays was unconstitutional because it was too broad about the meaning of obscenity and thus violated freedom of speech from the First Amendment. The argument from Reno was that the internet should be regulated like TV, and that the unrestricted internet would promote even more indecency, and the argument on the side of ACLU was that there was no way to distinguish between adults and minors on the internet for certain, and no exact definition of what is found indecent and offensive. The significance of this case was that it distinguished the internet from the broadcasting industry.